Hi everyone. In the second clip, I would like to talk about the topic of immunities. And immunities in this context have nothing to do with infections and pandemics, but rather with the limitations that exist on the exercise of sovereignty as set out in the previous clip. Before I get into the details, I'd like to highlight the general point that, just like jurisdiction, immunities are also the result of the principle of state sovereignty. So if exercising jurisdiction is about subjecting various entities, individuals or companies, to rules of conduct and to enforce these rules, then the principle, or rather the principles of immunity, draw our attention to the fact that these rules are somewhat different when it comes to other states. In the following, I'll go one by one through the three different types of immunities, starting with state immunity, then secondly to functional immunity of heads of states and other high officials, and third and finally to diplomatic privileges and immunities. The first type of immunity, state or sovereign immunity as it's sometimes called, relates to the state as an institution as opposed to its representatives, to which we'll get to with the second and third type of immunity. Now, if you think about the system of international law, about sovereignty and in particular sovereign equality, then it is not particularly surprising that a state and the exercise of jurisdiction of a state will find a limit in the sovereignty of another state. Now, there are two caveats to this. The first one being that if a state conducts itself in breach of international law, then you might not be able to address this breach before your domestic courts. However, you can deal with this international law breach as such before international institutions, for example, potentially at least, the International Court of Justice. The second caveat is that this state sovereign immunity is not absolute anymore as it once used to be, but that some questions can legitimately under international law find their way into domestic courts. And that is particularly so when it comes to commercial acts. So contacts and acts in which the state, rather than performing a public function that would be protected under international law, specifically the state sovereignty principle, actually becomes just another commercial actor, just like, for example, an individual that buys something or a company that enters into a commercial contract. Consider the example of a state hosting a reception on the premises of its embassy and hiring a caterer for this event that then delivers food and drinks. If indeed everything went fine and the service provider lived up to what it promised and was seeking to deliver, then the state has an obligation to respect this contract under domestic law. And this kind of commercial acts can in fact be enforced then under the domestic legal system of the hosting state. But when it comes to public acts, so acts that on some level in their nature are related to the exercise of state sovereignty and the performance of public functions, in those cases, state immunity still is a very powerful shield from domestic courts and the exercise of jurisdiction by another state. In fact, in the Ferini case, the International Court of Justice decided that even jus cogens violations, so violations of peremptory norms under international law, even those acts would be protected under the state immunity principle. This might be surprising given that it is the very definition of jus cogens norms that there is no exceptional derogation to them, but in this case, the International Court of Justice decided that any domestic court was precluded from even considering and evaluating whether a violation had taken place because the procedural barrier of the state immunity kicked in prior. So it kicked in and barred domestic courts even from instigating such a case. So eventually finding a jus cogens norm breach was therefore logically also precluded. Moving on from state immunity to the immunities of the representatives of states, there are two such kinds. On the one hand, functional immunity, and on the other hand, diplomatic privileges and immunities. And while they are somewhat distinct, the one thing that they have in common is that they are immunities from criminal prosecution, meaning that these representatives cannot be subjected to criminal proceedings in domestic courts of another state. These immunities also extend to arrest. So not only can state A not prosecute the representatives of state B in its domestic criminal courts, but arresting them would also be a violation of international law under indeed functional immunity and diplomatic immunity. Functional immunity, on the one hand, is the immunity from prosecution that is enjoyed specifically by heads of states, heads of governments, and foreign ministers, as confirmed by the International Court of Justice in the arrest warrant case, in which it indeed confirmed, being confronted with the question, that the Congolese foreign minister was shielded from criminal prosecution in the Belgian domestic courts. The notion here is yet again that even if the individuals have committed the crimes in question, putting them on trial would effectively infringe the sovereignty of the state that they represent. And this is so because these individuals perform very important functions within that state. Note then that it is only the head of state, the head of government, or the foreign minister that effectively enjoy functional immunity, and that any other government official cannot invoke such a principle to then be shielded from domestic criminal prosecution in another country. Now, the principle of functional immunity does find some limitations, specifically in those cases where officials are not in office anymore. The landmark case in this regard is the Pinochet case. Augusto Pinochet, former president and indeed dictator of Chile, was arrested in the UK in 1998 and was put under house arrest in response to an arrest warrant that a Spanish prosecutor had issued to prosecute him for crimes that he had committed during his time as president of Chile. Specifically, we are talking here about well-documented instances of torture and inhumane and degrading treatment that were committed during Pinochet's dictatorship in the 1970s and 80s. Eventually, Pinochet was not extradited to Spain and could in fact return to his native Chile, but that was so because of his deteriorating health condition. He was already very old. The UK House of Lords, so the highest judicial instance, had in fact decided that in principle he could be extradited to Spain were it not for his health condition, because these functional immunities did not apply anymore to somebody who was not anymore the sitting president, but rather just a former one. Note, however, that functional immunity for international crimes only pertains to domestic courts, and that in the case of international courts and tribunals, and most notably the ICC, even sitting heads of state, heads of government, foreign minister could in fact be put in the docket. So only domestic courts, not international courts, are barred by the principle of functional immunity. And finally, we have diplomatic privileges and immunities. And on some level, they resemble the functional immunities in the sense that they pertain to persons, and particularly to persons that represent the state, and that it is this representative function that gives them the protection. However, in the case of diplomatic privileges and immunities, these rules are set out in a bit more detail, and specifically they are set out in the 1961 Vienna Convention on the Law of Treaties. Now, the guiding principle underlying these privileges and immunities is the functionality principle, as laid down in Article 3 of the Vienna Convention, which stipulate that the immunities are in fact not personally applicable to the specific person, but are rather the one of the state that they represent. So this means that the moment that they cease to represent the state, these privileges and immunities are also not applicable anymore to the person. This also means that the host state has at least some say in matters regarding immunities and privileges. Specifically on the Article 4, the host state can actually reject the nomination of an ambassador or a consul by denying the so-called agrément that it has to give and the invitation that has to be extended. This, however, is not very often the case, so habitually, of course, states will accept these nominations and will extend this agrément for them to be the representative in their state. Moreover, if subsequently the diplomat does something that displeases, that angers the host state, think for example the commission of a crime, then the host state can actually declare the diplomat a persona non grata, an unwelcome person, meaning that they have to leave the territory within 30 days, and after this period they would actually not enjoy anymore their immunities, and they could, for example, be subjected to criminal court proceedings. Another key principle laid down in various provisions of the Vienna Convention is the inviolability principle, which extends to various things ranging from the embassy premises, the consulate premises, down to the diplomatic bag. All things that are considered necessary for diplomats to perform their functions, and which therefore are off limits and cannot be interfered by the host state. The Vienna Convention Article 31 also explicitly recognizes an immunity for diplomats from criminal jurisdiction by the host state. So in a way very similar to the functional immunity that I discussed before. The difference being here that according to Article 32, the state can in fact waive this immunity, meaning that in this very moment the state representative, the diplomat in question, actually does not enjoy this immunity anymore and could in fact be arrested and then tried by the criminal courts of the host state. There are actually more aspects included in the Vienna Convention on Diplomatic Relations, and we'll tackle some of these in the class exercise. But for the purposes of this clip, I limit the discussion to this. I look forward to discussing everything with you in class.